Roe versus Wade. Now that it's been overturned, it's necessary to learn what it was, how it formed, how it ultimately got overturned, and what does it mean moving forward. This is the full story of Roe versus Wade. The Roe versus Wade case was originally brought by Norma McCorvey, known by the legal pseudonym Jane Roe, who in 1969 became pregnant with her third child. McCorvey wanted an abortion but lived in Texas, where abortion was illegal except when necessary to save the mother's life. Her attorneys Sarah Weddington and Linda Coffey filed a lawsuit on her behalf in U.S. federal court against her local district attorney, Henry Wade, alleging that Texas's abortion laws were unconstitutional. A three-judge panel of the U.S. District Court for the Northern District of Texas ruled in her favor and declared the relevant Texas abortion statutes unconstitutional. The parties appealed this ruling to the Supreme Court of the United States. On January 22, 1973, the Supreme Court issued a 7-2 decision holding that the Due Process Clause of the 14th Amendment to the United States Constitution provides a fundamental right to privacy, which protects a pregnant woman's right to an abortion. But the court also held that the right to abortion is not absolute and must be balanced against the government's interest in protecting women's health and prenatal life. The court resolved these competing interests by announcing a trimester timetable to govern all abortion regulations in the United States. During the first trimester, governments could not regulate abortion at all in any fashion, except to require that abortions be performed by a licensed physician. During the second trimester, governments could regulate the abortion procedure, but only for the purpose of protecting maternal health and not for protecting fetal life. Once the pregnancy has progressed into the third trimester, the state may restrict the right to an abortion, but must always include an exception to any regulation that protects the health of the mother. The Supreme Court's decision in Roe was among the most controversial in U.S. history. Anti-abortion politicians and activists sought for decades to overrule the decision. But despite criticism of Roe, the Supreme Court reaffirmed its central holding in its 1992 decision in Planned Parenthood versus Casey. Generally, presidential opinions following Roe have been split along major party lines. The decision was opposed by Presidents Gerald Ford, Ronald Reagan, George W. Bush, and Donald Trump. President George H.W. Bush also opposed Roe, though he had supported abortion rights earlier in his career. Roe was supported by Presidents Bill Clinton and Barack Obama. President Joe Biden is also in favor of Roe versus Wade, but in a 2007 memoir, Biden wrote that although he personally opposed abortion, he did not have the right to impose his personal opposition onto others. Americans have been equally divided on the issue as well. A May 2018 Gallup poll indicated that 48% of Americans described themselves as pro-choice and 48% described themselves as pro-life. A July 2018 poll indicated that 64% of Americans did not want the Supreme Court to overturn Roe versus Wade, while 28% did. The same poll found that support for abortion being generally legal was 60% during the first trimester, dropping to 28% in the second trimester and 13% in the third trimester. Which brings us to modern day and the ultimate overturning of the landmark 1973 decision by the Supreme Court. And it all starts with Dobbs versus Jackson Women's Health Organization. The case was about the constitutionality of a 2018 Mississippi state law that banned most abortion operations after the first 15 weeks of pregnancy. Lower courts had prevented enforcement of the law with preliminary injunctions. The injunctions were based on the ruling in Planned Parenthood versus Casey, which had prevented states from banning abortions before fetal viability, generally within the first 24 weeks, on the basis that a woman's choice for abortion during that time is protected by rights of privacy under the 14th Amendment to the United States Constitution. Oral arguments before the Supreme Court from both sides were held in December of 2021. The decision was issued on June 24, 2022, ruling 6-3 to reverse the lower court rulings. A more narrow 5-4 ruling overturned both Roe and Casey. The majority opinion stated that abortion was not a constitutional right and that states should have discretion in regulating abortion. The court held the Constitution does not confer a right to abortion, and that the authority to regulate abortion is returned to the people and their elected representatives. This means that the issue of abortion now goes back to individual states, and these will be matters that will be resolved on a state-by-state basis. So, what's next? Well, from here, it's all up to the states. Many states with trigger laws in place immediately implemented them. Multiple Republican governors and attorneys general moved to call special sessions to implement abortion bans or to invoke their trigger laws to immediately ban abortions from taking place. Abortion laws in states that allow abortion are expected to become more permissive following the ruling. Proposals by California, Oregon, and Washington have included expanding abortion access by eliminating copays for abortion services, funding travel costs for those seeking abortion from states that ban abortion, and enshrining the right to an abortion within states' constitutions. The ruling has been said to create an independent legal framework by many legal observers, as the ruling has laid out a state's ability to determine independent abortion laws. And that's where we're going to leave it. As a result of overturning Roe v. Wade, it is safe to say that we're going to see a lot of different states do a lot of different things depending on what the citizens want. But I hope this video was informative, and as always, I appreciate your viewing. Take care.